Good afternoon, everyone. Thank you so much for joining us today. I would like to welcome you to our webinar on immigration status and social assistance, which is hosted by METRAC. My name is Andrea Collins Fitzpatrick, and I'm the Legal Director for METRAC's Community Justice Program. I'd like to start with land acknowledgement. Although we may all be located in different places right now, we acknowledge the territory on which METRAC is physically located. We acknowledge that this land is a traditional territory of many nations, including the Huron-Wendat, Haudenosaunee, and the Mississaugas of the Credit. Today, the meeting place of Toronto is still home to many Indigenous people. We honor all the First Nation, Métis, and Inuit people living on this land. We recognize the traditional territories on which our organization is located and on which our programs and trainings take place. I would like to remind you that this webinar is for general information purposes only and is not legal advice. The legal information provided is not intended to be used as legal advice for a specific legal problem. This presentation was developed by Community Legal Education Ontario and was adapted for its present use, and the information is current as of today. The webinar will be recorded and will be posted on our website at onefamilylaw.ca, so it's onefamilylaw.ca. I would also like to remind you that we will have a Q&A after the presentation. If you have any questions, please post them in the chat. And we will also have a survey that we would please ask that you fill out. It will be posted in the chat towards the end of the presentation. Before I move to our presenter today, I would like to tell you a bit about METRAC. METRAC works to end gender-based violence across communities through education, research, and policies. We've been in existence since 1984, so our 40th anniversary is next year, and the programs are devoted to advancing safety, justice, and equity. METRAC's Community Justice Program provides legal education and information related to gender-based violence, and through our Access to Justice program, we provide legal information in areas of family law, immigration law, criminal law, employment law, and human rights law. This webinar is part of our Family Law Education for Women FLU series. FLU's resources are available in 14 languages, ASL videos, and accessible formats. You can visit our website at onefamilylaw.ca for more information on your family law matters. So this afternoon, I am so delighted to have Rosie Thompson to speak to us about immigration status and social assistance. Rosie is an immigration and housing lawyer with Mississauga Community Legal Services. Before joining the clinic system, she practiced as a criminal defense lawyer, specializing in representing clients diagnosed with mental illnesses. Rosie is passionate about providing access to justice for clients who face systemic barriers. She also enjoys writing, running, baking, and learning about current affairs around the world. I'll now pass things on to Rosie. Thank you so much, Rosie, for being here today.
Thank you. I'm really excited to be here. And so I want to just introduce myself officially. My name's Rosie. I know it says Rosalie in the slide, but everybody calls me Rosie. So like Andrea said, I'm a lawyer at Mississauga Community Legal Services. I will note I'm not a social assistance lawyer. So while I'm an immigration lawyer and I'm presenting on kind of intersectional topics between immigration law and social assistance, I'm not a social assistance lawyer. So I myself am always still learning about the ways that the two areas of law intersect. And just briefly, I'll just say what we do at Mississauga Community Legal Services. We're a community clinic. We're one of 73 legal clinics in Ontario that are funded by Legal Aid Ontario. And some of our other clinics, like we provide services to people who live in Mississauga who are low income. Some of the other clinics are more specialized. So, for example, there's the Income Security Advocacy Center, or ISAC, and they have great public legal education resources specifically having to do with social assistance. And I also just want to shout out the Community Legal Education Ontario, who developed this presentation. Their website is incredible and has a lot of really easy to use tools and really accessible information on it as well. So the aim of this training today is not for you to come out as experts in social assistance or immigration law, but rather to increase understanding and become familiar with helpful resources that you can share with your clients and colleagues. This is the agenda. I will try to stick to it. So we'll start off with a myth-busting activity. If we were in a more interactive setting, we could have a discussion about this, but I'll just pose the question, give you a second to think about it, and then I'll discuss the answer. The first myth that I'll put out there is I can only get Ontario Works if I was born in Canada. So maybe just think about whether you think this is true or false. And I'll tell you the answer is actually false. So we'll discuss the range of immigration statuses that can be eligible for social assistance in Canada. You don't have to be born in Canada to get OW. Next slide. Receiving OW will affect the outcome of my refugee claim. The answer for this is also false. Refugee claimants are entitled to OW, and there should be no impact on how the refugee claim is decided if they receive social assistance. Can you sponsor your spouse if you receive ODSP? This is a bit trickier, but the answer is it's true. You can sponsor your spouse if you receive ODSP. Conversely, you may not be able to sponsor them if you receive OW. So if you're receiving social assistance for a reason of a disability, you are eligible to sponsor your spouse. But the rules say that if you are receiving Ontario Works, you can't sponsor. There are some ways around that. And if you are in a situation or have clients in a situation where you're receiving OW and want to sponsor a family member, then it's best to get a lawyer involved at that point, because you'll have to make special submissions to really get around that requirement. Okay, last question. If I leave my sponsor, I can apply for OW, true or false? And this is kind of a trick question because the answer is really maybe. It's a little more complicated. As we'll discuss later in this session, the answer really depends on whether the sponsor is still obligated to support their spouse under their contract with Immigration, Refugees, and Citizenship Canada through the undertaking that they signed when they applied to sponsor. Okay, so these are the answers to all those questions that I posed, and we'll just go on to the next slide. So this presentation is kind of broken down into two different parts. The first part, I'm going to talk about how immigration status can affect eligibility for social assistance, specifically Ontario Works and Ontario Disability Support Program. And I'll be referring to those as OW and ODSP. I probably should have clarified that at the outset. But going forward, OW means Ontario Works, ODSP is Ontario Disability Support Program. The second part of the presentation deals with how does receiving social assistance affect my immigration application or affect immigration applications. So I'll kind of look at it from those two perspectives and we'll move forward. Okay, I wanted to include just some information to let you know, and I'm sure everyone who's attending this webinar is well aware that the reality is that there are so many barriers that we and as service providers, our clients face when they're trying to get immigration status, and simultaneously they're struggling to survive economically, especially in this particular climate. We always try to keep in mind the many barriers that exist, especially for refugees, for live-in caregivers, for migrant workers, and undocumented people and people with precarious immigration status in Ontario. The fears about losing status or fears about stigma about not having status, language barriers, lack of information, and resources really compound that disadvantage for folks who are needing to be on social assistance and also have immigration issues. And we know that there are many people in Ontario that are living in, what we call deep poverty. So that's people on social assistance, and where social assistance is often so inadequate to meet people's daily needs. that creates a host of issues for people. And sometimes barriers come from within the social assistance institutions themselves. So this presentation is really aimed at addressing some of the misunderstandings and the reluctance to accept applications for social assistance, and embolden you to advocate for yourself or for your clients to push past some of those misunderstandings. And if there is a denial of social assistance, to request a decision, because with a decision, you have something to challenge legally. So we'll get to that. So this is just the title slide. I'll start by discussing how immigration status affects receipt of social assistance. So I'll start by discussing access to social assistance for citizens of Canada. It's pretty straightforward. You're likely a citizen if you're born in Canada. You can also apply for citizenship to become a naturalized citizen if you're born outside of Canada. And you may have received citizenship as a minor when a parent or a legal guardian applied for citizenship. There's many pathways to citizenship. And next slide. So the bottom line is citizens are eligible for social assistance. No surprise there. Of course, everybody who applies for social assistance has to meet other eligibility criteria. So that's, your income level, your assets, your family unit, where you live. And you can prove citizenship by showing a passport, birth certificate, or a citizenship card. Next slide. Permanent residence. So what do we mean when we say permanent resident? It's someone who's been given permanent resident status in Canada, and that permanent resident status has not been taken away. So there's many ways to obtain permanent residence. You can, economically immigrate. You can have a successful humanitarian and compassionate application. Maybe somebody sponsored you. But permanent, I do want to bear in mind that despite the word permanent being in that, name, permanent residence is not always permanent. It is possible to lose your permanent resident status. That could happen as a result of a criminal process, or if someone's outside of Canada for too long and immigration determines that they don't meet the residency obligation that they have. It could be taken away for misrepresentation or, a lie on an application to immigration. And all of these processes and concepts are really beyond the scope of the presentation today. But the take home is that PR status or permanent resident status is not as permanent as it sounds. There are ways that it can be taken away from people. And just to mention, sometimes people say landed immigrant. That's the same thing as a permanent resident. So how does social assistance treat permanent residents? They are eligible, just like citizens, as long as a permanent resident meets that other criteria. To prove permanent resident status, folks can use a PR card, their record of landing, which now it's electronic, but it used to be that yellow piece of paper that people got when they came to Canada as permanent residents and they were landed, or a confirmation of permanent residence letter, which is something you get usually before you get the PR card. The next category is people who've applied for permanent residence. So these are permanent resident applicants. This means this is somebody who submitted an application to IRCC, Immigration, Refugees, and Citizenship Canada, to become a permanent resident of Canada. However, they have not yet received approval. So that could include folks who are being sponsored, like the sponsorship process is underway. It could be a successful refugee claimant or protected person, because when you're granted refugee status, the next step is to apply for permanent residence. You don't automatically get it, although you do become eligible for it. And another example is someone who submitted what is called a humanitarian and compassionate application, or an H&C. This is really the bread and butter of our legal clinic. Like an H&C application is an application made on humanitarian grounds to persuade the government of Canada to grant someone permanent residence when they don't qualify under any other category. We deal with a lot of HNC applications at the clinic. So I've already kind of launched into this, but an HNC application is discretionary, which means, when you sponsor someone, as long as you meet the eligibility requirements, that person you're sponsoring is going to get PR. You have a right to sponsor, your dependent children and your spouse. Someone applying for permanent residence with an HNC application does not have that same right. So it's really up to the officer deciding the application, whether they've met the test and shown that there is, enough evidence of humanitarian and compassionate grounds to grant the application. The other thing about an HNC application, unlike other types of applications, such as pre-removal risk assessments, for example, there's no stay of removal while you're waiting. So sometimes the wait for an HNC application to be processed can be like 4 years, which is very painfully long wait. And if somebody has a removal order, which means otherwise known as a deportation order, but we call it a removal order in Canada. Someone is subject to a removal order that is not stayed during their HNC application's processing. So that means that they could be removed from Canada before their HNC application is processed. In looking at these types of application, immigration is going to look at 3 main areas. They're going to look at people's establishment in Canada, how much ties to Canada do they have? Do you have Canadian-born children? Are you involved in volunteering or a faith group in Canada? They're going to look at hardship on return to your home country. So not the same, test as a refugee claim, but how hard would it be for you to reintegrate into the country where you came from? And another factor that immigration will look at for HNC applications is the best interest of any child affected. And when clients submit an HNC application, we have to always warn them that there's increased visibility. That means that immigration now knows who, that you're there that you're here without status, and that has some risks. And in this context, receiving social assistance as an HNC applicant is often viewed negatively by immigration officers. So if I have a client who's receiving social assistance and I'm doing an HNC application for them, I want to make it very clear that, there's lots of really good reasons why they're on social assistance. On balance, it's usually, and this is, totally case dependent, but usually it is better to be doing unauthorized work than receiving social assistance from the point of view of an HNC application. But there's lots of cases where people have a great HNC application, a really good reason to stay in Canada, and they also have really good reasons to stay on social assistance. So that's something, those are more complicated applications, and it's up to the lawyer to really convince the officer. So how does social assistance treat people who've applied for PR? Many, and this is a maybe. It depends is the answer, really. Many PR applicants are eligible for social assistance as long as they meet the other eligibility criteria, but they may need a bit more documentation to be successful. So you can use a copy of the cover letter that you sent in with your PR application, or the acknowledgement of receipt that immigration gives back when they receive the application. And frustratingly, sometimes immigration takes a long time to issue that acknowledgement of receipt. So clients are left in limbo. They submitted an HNC, but we're still waiting for that official acknowledgement of receipt to convince their caseworker that they are eligible for assistance. Folks might submit proof of payment for a PR application, or the best scenario is a letter from their lawyer saying this is what they've submitted. We're waiting for the determination on their PR application. Okay, refugee claimants. Pretty straightforward, but maybe not. It's somebody who's made a refugee claimant and is waiting for their decision, has not yet been determined to be a refugee. But it can also include people who have lost their refugee hearing and are now appealing to the Refugee Appeal Division. So as long as that appeal process is still ongoing, they're going to be considered as refugee claimants for the purposes of social assistance. It could also apply to folks who are applying to the federal court for judicial review of a negative refugee decision. And refugee claimants are eligible for social assistance. This is before there's a final decision on their claim. So it used to be that refugee claimants could only get emergency assistance that had to be renewed regularly. Now refugee claimants are eligible for regular social assistance. But caseworkers will often, like when somebody is a PR applicant or a refugee claimant, caseworkers will often ask for updates on a regular basis. So it's handy to, if you're in this situation or you're working with a client who's in this situation, to have a good relationship with the immigration lawyer so that you can provide those updates about the client's status. Protected persons. So protected person is different than a refugee, although there is some overlap in the legal tests, but a protected person is someone whose claim for protection was accepted. So it can be somebody who is a convention refugee, or it can be a person in need of protection. For example, there's something called a pre-removal risk assessment, which is a type of application that some people with removal orders from Canada are eligible for. And if you're successful in your pre-removal risk assessment, you're also a protected person. So that's who protected people are. And how does social assistance treat them? Next slide. They're eligible for social assistance as long as they meet the other criteria. And they're probably going to have to provide some kind of documentation of their status. So we normally would provide a notice of the positive decision from the Refugee Protection Division or the Refugee Appeal Division, a notice of a positive PRA decision, that's that pre-removal risk assessment that I referred to earlier, or that a temporary resident permit has been issued for their protection. And next slide. Oh, PRA applicants. Okay, good. So this is the pre-removal risk assessment applicants that I was talking about. So people who've applied for a pre-removal risk assessment or a PRA are eligible for social assistance. There is going to be a need definitely to show documentation, confirming that you've been served with a PRA, proof of ineligibility to make a refugee claim, the notice of appear for a PRA hearing, if there's a hearing, often there's not a hearing, or a letter from a lawyer. PRA applicants are seeking protection from the Canadian government. So in that way, they're treated similarly to refugee claimants. And I won't get into this specific process of applying for a PRA, but suffice to know that they are really treated similarly to refugee claimants. All right, and now we get into the really interesting stuff. What about people who do not have immigration status? And at our clinic, we deal, I would say, mostly with people who don't have immigration status. So that could have happened for a variety of reasons. Sometimes someone's status expired, but for whatever reason they could not or did not go back to their country of origin when their status expired. It could be a refused refugee who didn't leave Canada. Like maybe it's someone who has a valid fear of leaving and going back to their country of origin, but they were not able to win their refugee case, and so they're left without status. It could be a person who's stateless. It could be a situation where someone has been sponsored, but the relationship broke down before they became a PR, and they're left in Canada with no status. Also, somebody who's entered Canada between two border points who has not made a refugee claim. So those are like irregular entries. They don't have status either. So in answering the question of how social assistance will treat people without immigration status, next slide. Social assistance is going to be really focused on whether the person applying for benefits can be removed from Canada. So the question that they will ask about applicants who do not have status is whether the removal order is enforceable. That means, whether Canada can, in reality, actually carry out a removal. These are the different types of removal orders that people without permanent status can have. There's departure orders, exclusion orders, deportation orders, and I don't need to get into the weeds too much, but the bottom line is, can the removal order be enforced? Next slide. And not all removals orders can be enforced. So it is possible that somebody could have no status and be subject to a removal order, but they still qualify for social assistance. And in fact, some people live in this kind of in-between state for many, many years in Canada. So during certain processes, you can't be removed. So, if you've applied for a PRA and some types of appeals and judicial reviews, there may be a removal order, but it's stayed, which means it's put on pause until the outcome of whatever process is going on. Canada also has a list of countries where they will not remove people to, and you can Google it, and it is, it changes from time to time depending on country conditions. But Canada, if you're from a certain country or you have clients from a certain country, they're not going to get removed to a country that Canada has deemed to be too unsafe to remove anyone to. There's also situations where CBSA, Canada Border Services Agency, may agree to defer someone's removal. There are circumstances where people can convince CBSA to put their removal on hold and defer it until the outcome of some other process that they have going on. There's a more official process to get removal orders stayed too, and that's by going to federal court and arguing for a stay of removal. And that's an application that a lawyer can make for people who are facing removal, but there's really good reasons for them not to be sent back to their country of origin. There's also sometimes CBSA has practical difficulties removing people. So, for example, somebody doesn't have a passport. Well, they're not going to be able to be removed until that passport is issued. And in that interim period, they are eligible for social assistance. I should just add too, people waiting for a criminal trial can't be removed. And, you can get a letter from a lawyer to prove this, and then you may still be eligible for social assistance. So how does social assistance treat people with removal orders? Not eligible if there's an enforceable removal order, unless it can't be enforced. So I've gone over the many ways that a removal order may be put on pause or not be able to be enforced. During that time, people are eligible. If there's an enforceable removal order and someone has made an H&C application or can't leave for reasons, quote unquote, beyond their control, then those folks are eligible for social assistance. To prove that you made an H&C application, it's a good idea to get a letter from a lawyer or that acknowledgement of receipt letter that I was talking about earlier, and submit that to show that you have something underway, a PR application underway. Reasons beyond people's control can include, like I discussed earlier, CBSA is having difficulty getting a travel document. I have the link to the CBSA webpage that connects to the list of countries where Canada won't remove people from. I think it's in this presentation, but if it's not, I'll email it to Andrea afterwards and she can circulate it if anybody needs that. Okay, next slide. Temporary resident permits, or TRPs. A TRP used to be called a minister's permit, and it's a discretionary tool in the same way an H&C application is discretionary, but it's a way to get around or overcome an inadmissibility. So, for example, if someone is medically inadmissible to Canada or criminally inadmissible, but they have a really good reason to be in Canada, at least on a temporary basis, this is a document that's issued by immigration that allows people who are technically inadmissible to either visit the country or stay temporarily. So this could be, for example, victims of human trafficking, vulnerable workers. And I just want to make a distinction here, too, between TRPs and TRVs. A TRV is a temporary resident visa, and it's a document issued to visitors and students and workers, and it's usually put right in the passport, and that's different than a TRP. So how does social assistance treat TRP holders? This is a depends answer. So TRP holders may be eligible for social assistance. You want to, provide a copy of the TRP and a letter from a lawyer if that's possible. And it's really this is a really unsettled point, and it's kind of beyond the scope of this beyond the scope of this presentation to get into whether somebody from with a TRP is eligible for social assistance. But it's enough to say if you have a TRP or a client with a TRP and they apply for social assistance, don't let your doubts about whether someone qualifies hold you back from applying. Apply, get the decision letter, and then take it to a lawyer who can review it and see if there is a good basis for challenging it. Because I think there's lots of situations I can think of where somebody with a TRP there may be very good arguments to entitle them to social assistance. Okay, next slide. Visitors. So it's hard to really define what a visitor is for the purposes of social assistance. It's not defined in immigration law or by the ministry's policy, but we can understand it in its ordinary meaning, which is here. It's a person who visits a person or place. It's to go to a place, to look at, to spend time there. It's not somebody who's intending to put roots down in Canada. And OW, Ontario Works, and ODSP are not available to people who are visiting. So if social assistance finds that someone is a visitor, they are not going to be eligible for social assistance, as opposed to people who've established a residence here, whether it is or is whether they are or are not authorized by the government to be here. So that will really come down to an individual's facts. Okay, next slide. I believe this is like a handy chart that's going to be in the slides put online. If we were in person, I would have hard copies to hand out to people, because I find these charts really visually easy to navigate, and you can kind of use it to determine whether somebody is eligible. So next slide, tourists. Tourists are also not defined in the law. They tend to be lumped in the same category as visitors, and presumably we can understand this word in its ordinary meaning as well. Social assistance policies do have a definition for tourist, and it's a person who's in Canada for a short period of time. So you can see how that kind of conflates tourist and visitor. So how does social assistance treat visitors and tourists? The simple answer is visitors and tourists are not eligible for social assistance unless, 1, they've made a refugee claim, or 2, have applied for permanent residence through an H&C application. So we have a scenario-based question to kind of get people thinking about people who are in situations where they didn't come to Canada with any official pathway to permanent residence, but still they are eligible for social assistance because of the unique factors of establishing residence in Canada. So in scenario 1, I will just read it. Alana arrived in Canada as a visitor 2 years ago. Alana left her country of origin because she was afraid of an ex-boyfriend and the police. She realized after she got to Canada, it really wasn't safe to return home. She stayed without status. She had a son. She received healthcare for herself and her baby, and she developed friendships here in Canada. Alana did apply for refugee status, but the process was confusing, and she found she needed a lawyer, so there's been some delays. She finally has a lawyer, but she has not filed her refugee claim yet. The question is Alana eligible for Ontario Works benefits? So I'll go on to the next slide and answer that for you. The answer is yes, but the ministry policy and local Ontario Works offices, of course, say that Alana is not eligible for Ontario Works because She doesn't have permanent residence. She doesn't have any permanent resident application underway because she hasn't made her refugee claim yet. However, there are some factors that are unique in her situation. So her lawyer is able to successfully appeal the determination that she's not eligible and convince the tribunal that she can get OW. And this is based on a real case. And the tribunal in this case found that Alana, of course, we're not using real names or anything, but we'll say Alana for the purposes of this exercise, that the appellant or Alana's circumstances, including the duration of her stay, how long she'd been in Canada, her integration into the community, the friends and connections she'd made, along with other hallmarks of permanency, are inconsistent with and not indicative of someone who is a visitor. Rather, they are more indicative of establishment in Canada, and Alana should not be considered a visitor. So in making this decision, the tribunal considered factors like the fact that shortly after she arrived as a visitor, Alana made a decision to stay in Canada due to her fear of returning home. She began a relationship here, and even though that relationship had ended, Alana had gotten pregnant in the course of that relationship and had a baby who was born in Canada. She found housing in Canada. She had really good health care attending to her needs and her baby's needs. She developed a supportive network here. And early on and over the course of her stay, she sought legal advice on how to make a refugee claim, but this did take time. She eventually did submit her refugee claim. But this was a case where even though the Ontario Works Office denied Alana benefits at first instance, her advocates were able to successfully get her OW based on all those other establishment factors. So there is some gray areas here, and there's a lot of room for advocacy for people who need social assistance, but who have no status, and in Alana's case, haven't even made an application for status at that point. So next slide. I think it's slide 39. Yeah. So this is just kind of a summary to try to simplify it. The people who are not eligible for social assistance are those with enforceable removal orders and who haven't applied for PR based on agency grounds, who can leave the country. Visitors who have not made a refugee claim or a PR application are not eligible for social assistance, and tourists. If someone doesn't fall into those three categories, it's worth applying. And if someone is denied, it's probably worth fighting that denial and appealing it. This is another chart. It's just sort of like a tool summarizing the previous section. I will note too, social assistance, there's a new online application system for social assistance. I don't use it myself because I'm not a social assistance lawyer or a social worker, but I understand it's being used in some reasons, and it deems someone with a TRP ineligible. And if you say you have a TRP, it just won't complete the application. It also has a status category of deportee, which is not very helpful, as we've discussed, because people may have a removal order against them that's not enforced. So what we're saying for people who can't complete their application through this online system because of those strict determinations, they should call their social assistance office and get help to complete it by phone, and then be referred to their local legal clinic for help. Just some of the barriers to getting social assistance. Sometimes people who have precarious immigration status or not regular status are denied social assistance. They may be discouraged or even applying, or discouraged even from applying because of the definition of who is a visitor. That definition can be very confusing, and it's subject to a lot of misunderstanding. So it's really important, like I said, push for that written decision, because with that decision, you can, at least get advice to see if there's something to challenge. So this little chart or guided pathway, it tells you what to do if an application is denied. So for example, if you apply for social assistance, your application was denied, you've got 30 days to write a letter asking for an internal review. And that's what I'm talking about, that at least getting a decision, getting to the stage of getting a decision, then, you may there may be something there that a lawyer or another advocate can help you work with. All right. What can community workers do? Definitely make sure that clients have immigration representation or have received advice about their immigration matter, and encourage clients to apply even if they don't think they qualify. But if they have an immigration lawyer, talk to the immigration lawyer first, because in that application, the immigration lawyer may be able to suggest documentation or provide documentation that can, get them granted at first instance. Help clients complete social assistance applications even if they're told verbally they're not eligible for benefits. So that's that thing again. There's so many misunderstandings and barriers kind of built into the system that, sometimes if people are denied, sometimes people, if they're told they're not eligible from someone that they, see as a position of authority and knowledge, just won't apply, but they may actually be eligible. And refer your clients to local legal clinics, and we can look at their eligibility. We can help them file internal review requests. We can file appeals, and we can also help them request interim assistance to get them by in the period until between when their application was denied and when their appeal or internal review is decided. All right. I do have the slide in the middle that says questions, but I believe we're saving questions till the end, so we can keep moving to the second part of our presentation. And this is sort of asking that inverse question. Now we're asking how social assistance is going to affect immigration applications. And admittedly, this is more my area of comfort. In immigration law, social assistance is defined as the following. It's any benefit in the form of money, goods, or services provided to or on behalf of a person by a province under a program of social assistance, including a program of social assistance designated by a province to provide for basic requirements, including food, shelter, clothing, fuel, utilities, household supplies, personal requirements, and healthcare. So in immigration, for example, getting a daycare subsidy is a form of social assistance, and that's something I need to, if I'm making an H&C application, I'm going to have to contend with as somebody's immigration lawyer, is, disclosing that they receive a child care subsidy and explaining why that shouldn't make them disqualified from getting a PR through an H&C. How does social assistance affect immigration applications? Okay. So most immigration processes will be affected. I saw a question come up in the chat, and I'm not sure if we may answer it in the next slides. But if not, we'll definitely come back to it. Some people with certain immigration statuses are sheltered from immigration sanctions as a result of being on social assistance, like protected persons or refugee claimants. So we're going to focus in this presentation on social assistance and its potential impact on sponsorship and being the person sponsored. The sponsor and the person being sponsored. And I do want to clarify, because I think this creates a lot of, this is something that I've noticed that people do get confused over. In a sponsorship application process, the sponsor is the person who is bringing their relative or their loved one to Canada. The person being sponsored is referred to in the immigration application as the principal applicant. So sometimes that gets confusing because people will think that when they're the sponsor, they're the applicant because they're applying to bring their loved one to Canada. They're the sponsor, and then the principal applicant is the person being sponsored. And we're talking about sponsorship in the family class. Protected persons and convention refugees can bring family members into Canada, but this isn't considered a sponsorship. This is considered family reunification. So we're talking about Canadian citizens or permanent residents who are able to sponsor family members, such as their spouse, dependent children, and in some cases, other relatives, but that's more limited. All right, next slide. So what about when the sponsor is receiving social assistance? The bottom line is, it's fine if the sponsor is on ODSP. It's probably not fine if they're on OW. So when a sponsor is in receipt of social assistance, other than for reasons of disability, the sponsorship application will be refused unless there are compelling humanitarian reasons to approve it. So definitely if someone on OW needs to sponsor someone, it's not impossible, but they're going to probably need the help of a lawyer to bring enough evidence to override that exclusion or convince the officer deciding their application that there's, really good reasons why they need to be on social assistance. If someone is on ODSP, that's fine. I mean, I think the rationale there is if somebody has a disability, that's not something that they can control. I would also think that a lot of the reasons people are on OW are not things they can control, but there is a difference there in law that we have to contend with. Immigration has indicated that for the purpose of sponsorship, subsidized housing and daycare are not social assistance. And so that's different. I think I just mentioned in the context of an H&C application, a subsidized daycare is considered social assistance. For sponsorship, it's not. It's really important that everybody in the process declares whether they are in receipt of social assistance. I think it can be extremely harmful to someone's chances of sponsoring or being sponsored to misrepresent in their application, even if it's inadvertent. Misrepresentation can have huge legal consequences that can follow people for years and years. And so it's, you have to be upfront and honest about it. And chances are, if you're not, immigration is probably going to discover it anyway. And you do not want to be in a situation where that happens. So next slide. Oh, I should just mention as well, for housing and childcare subsidies, it's possible if someone is receiving a combination of these subsidies that immigration could view it negatively and consider them to be on social assistance. So, while a daycare subsidy on its own is probably not a problem, if there's a lot of different subsidies, then immigration may view that negatively. If the applicant is on social assistance, so that's the person who is being sponsored. Even if the sponsor is on ODSP, which is totally fine, and the sponsorship application is pretty routine, the applicant, so the sponsored person, has to convince immigration when they come to Canada, they will not be relying on any form of social assistance, including ODSP. So that means that the sponsored person needs to show that other arrangements have been made for their support in Canada. They're not going to be included in the benefit unit of the sponsor, and they're going to be able to get by without social assistance. And I think the next slide, it's slide 52, and we have a scenario regarding sponsorship and social assistance. So in this scenario, Mario and Raul, Mario has applied to sponsor his spouse, Raul. Raul lives with him and is in Canada, but does not have status. So Mario wants to sponsor him. Mario's on ODSP. And Raul has been included in Mario's benefits unit as his spouse. But Raul does not have a disability himself. So the question is, will this affect Mario's application to sponsor Raul to become a permanent resident? And secondly, would you change your mind if Raul also suffers from a disability? So in terms of the first question, Raul can certainly apply to sponsor his spouse because he's receiving ODSP, not OW. And the immigration rules allow you to sponsor if you receive social assistance because of a disability. However, he's got to remove Raul from his benefit unit. So Mario needs to remove Raul to avoid immigration consequences. They should both remove Raul and then get that documentation from ODSP that they've asked for him to be removed or that he has been removed, and then share that with immigration before a decision is made on the PR application, because if they don't, they could be denied. We don't really have time to get into that second part of that scenario, so I apologize for that. But going back to the last slide, responsibilities of sponsors. When you sponsor somebody, you have to sign something called a financial undertaking, and it's really a promise that you will provide for your family member for a certain period of time after they either get to Canada or get PR status if they're already in Canada. It's required so that the government can be satisfied that sponsored family members won't need to ask the government for financial support, at least for that period of time when the undertaking is in effect. So, and then sponsored family members, of course, become permanent residents with the idea that they will be able to work and live and study in Canada. So next slide, how long is the undertaking? And that depends on who you're sponsoring. So for partners or spouses, that's 3 years. You have to be responsible. Dependent children under 22, 10 years or the age of 25, whatever comes first. Dependent children over 20 years, 3 years is the length of the undertaking. And for parents, grandparents who are sponsored, the length of the undertaking is 20 years. For anyone else, it is 10 years. So it can be a very significant amount of time. And I'm sure folks either have encountered or heard of or can imagine the difficulties that come up, especially in the situations of spousal sponsorship, where there's a sponsorship underway, or maybe someone has already received PR after being sponsored and the relationship breaks down. So we'll go to the next slide, and I just want to show you an example of an undertaking. This is the undertaking that the sponsor will sign. Okay, and the important part is highlighted there. I promise, well, it's all important. It's all important, and it needs to be read very, very carefully, and everybody needs to get advice about this and have a chance to ask an immigration lawyer, questions about what this entails. But when you sign this undertaking, you are promising the government that the sponsored person and his or her family members that are coming with them as dependents, if that's happening, will not need to apply for social assistance. So next slide. This is what it looks like for the principal applicant or the sponsored person. In this undertaking, you have to understand and agree that it remains in effect no matter what life changes happen, breakdown of a marriage, and that that could be included, and that we'll talk about sponsorship debt, but that the decision of the government not to act on a debt does not cancel the debt. So sponsorship debts or debts that are incurred when somebody who has been sponsored does end up going on social assistance, that they don't go away. There's ways to advocate for them to be deferred and payments to be reduced and spread out over a long period of time, but they do not go away. So next slide. So now we're going to talk about sponsorship debt. If a sponsored family member gets social assistance during the undertaking period, that's going to come back on the sponsor, and the sponsor may be found to be in default. They will be asked, well, they may be asked, but they will be asked at some point to repay the government the amount of social assistance that their family member received. So we have another scenario, and I'll read it out loud here. Selena sponsored Isaac as her spouse, and he became a permanent resident in 2019. After coming to Canada, unfortunately, he became aggressive, and he would often yell at Selena. Selena didn't feel safe, and her friends offered her help to leave him. The question is, does Selena have to continue living with her husband in that abusive relationship? And next slide, of course, the answer is absolutely not. Selena's safety and security are the most important thing in that situation. And if Isaac has received permanent residence before they split up, nothing's going to happen to his status either. It does get a bit more complicated if the sponsorship is underway and they split up. They may be refused because immigration might say they no longer are in a relationship. But as long as Isaac has PR before they split up, it's not going to affect his PR. Isaac also has no obligation to remain in that relationship. However, second part of the question, if after they split up, Isaac applies for social assistance, will Selena be in default of her undertaking? And the answer is yes. Selena will likely be found to be in default. Again, reiterating that her safety and well-being is the most important, but this is a consequence that unfortunately does occur. the government has some wiggle room to defer payments of those debt or accept a minimum monthly payment. So sponsors in this situation should definitely get some legal advice about how to convince the government to defer the payment of the debt. That is, put it on hold so it does not need to be paid right away. And there's also situations where people are able to work out repayment agreements that are very, very, very low. You really have to bring evidence to show the hardship that you would incur if you had to pay it all back all at once. And I also want to note, just especially for service providers who are assisting people in situations like this, it's not been tested properly in the courts, but there's a possibility that Selena could also have a claim against her former partner for the debt she's accrued. So if Selena does get a letter saying she owes a sponsorship debt, she should get legal advice. I mean, some legal clinics are very interested in what's called test case litigation. So that means, going to court with really good facts to get decisions that will positively affect not only the person who the lawyer is advocating for, but lots and lots of people. In other words, like, we might be able to change the law through court cases. So I would encourage anybody who knows somebody or who is in a situation like that to just talk to a lawyer and see if there's any possibility of taking it further and maybe making a claim against the person who was abusive. Okay, next slide. This is a handy chart. It'll be in the materials. It presents the information in a very accessible way. All right. So what can community workers do? Again, it's important to recognize the difference between ODSP and OW for some immigration applications. Again, warmly refer your clients to local legal clinics. And when I say a warm referral, it's like an email from a caseworker or a social worker or, a community agency referring a client can really help a community legal clinic grasp what the legal issue is and know what supports that client has in the community. So I always like to get warm referrals because it also means we can work with that community agency or that social worker to advance the client's rights in their case. If the person has an immigration lawyer, talk to the immigration lawyer first, obviously. And help clients who are facing those barriers because of language, because of disability, or because they have precarious status. Push the envelope, get the written decision, and then bring it to a lawyer.